talking about the version of the civil society on the amendments to the Constitution in terms of justice, civil society opinion. Roman Kuybida, Petro Varyshko, Mykhailo Zhernakov will be the experts, and also will be the participants, and Taras Shepel, the expert of RPR. The floor is yours. Good afternoon to everyone. I'm happy to see you all. Karl Volokh had to join us, but unfortunately he has a different meeting now. But he's with us. He's been supporting our ideas, and he sent his best regards to everyone. Now, as to why we selected this topic and why we decided to present our own version of the amendments to the Constitution, because we criticize the president a lot, we criticize the advisory body, the constitutional committee under the president, but we in fact are not criticizing the president, we are supporting the president, because the president has been mentioning that it is important to reboot the constitutional system, because what is developed in the Constitutional Commission is not even the reform of the judicial system. Why? Because there are some issues of principle. The draft was finally published yesterday. One of the critical things that we emphasize is that the document was not publicly discussed, and 2 days before the text is to be approved, they finally published some text. So in that text we found several things which scare us, because if they are passed like that, we cannot talk about any judicial reform, and there are things which are missing there, which had to be there. First is that what we presented here in UCMC, and that is what is missing in the draft amendments to the Constitution. This is reappointment of all the judges. That is what the civil society insists on, and that is what the president is talking about, and that is what many political forces are insisting on. If we do not create the judicial system, the new judicial system, which will be similar to what was happening with creation of the police, patrol police, then if we do not have new judges in this system, then the reform will not be efficient. We also read the interview of Alexei Filatov, who said that that to reappoint all the judges is just like treating the head pain by guillotine, but this is not the head pain, this is the cancer on the body of the system. These are judges who are not ready to really provide for justice, but now we would like to mention what else is missing there. There is the 4-level system of courts, which was criticized by everyone. Unfortunately, they have not avoided it in the process of the discussion, and also the political influence on judges is not eliminated partially. The Verkhovna Rada is removed from that, but the presidential influence is still preserved. The Venice Commission mentioned that after the powers of the president should be only ceremonial, and after the judges are appointed, any contact with the authorities, with those who are in power, should be disconnected. So there is one very serious change. Now it says that the president appoints a judge to the position. Now it says that judges are appointed to positions, not to position. This way the president can also have powers to move judges, which will mean that he will have influence on the career of every judge. And this will mean that this branch of power, which should not be influenced by any other branch, will be influenced by the presidential branch. And so the new system of judges is to be three-level. All the judges are to be reappointed according to transparent procedure, which will control three things: the reputation of a judge, his property, and his ability to judge. Without that, the reform will not be successful. So we addressed Mr. Groisman to ensure that the public is present at the plenary meeting of the Commission. We presented our version, which will be sent to all the members of the Constitutional Commission, so that at the plenary meeting the amendments could be passed which will introduce real judicial reform, but not the one which they are trying to sell to us. They are saying that all the amendments which are suggested by the Constitutional Commission are the reform. And now Roman Kuybida. Good afternoon. The President yesterday providing comment to the sentence issued to two Ukrainian citizens, said that in Russia there's no just court. Unfortunately, we don't have a just and fair court in Ukraine. The potential that the judicial reform can get, it should be implemented. Approximately 2 weeks ago, the members of the Constitutional Commission presented the working group drafts. We managed to react only after we saw the text itself. The text is published a few days ago, and so we saw that this draft, which has been developed by the Constitutional Commission, does not achieve two objectives. First, it does not achieve the real independence for judges, and the second, cleaning of the judicial core.
The same judges who actually sentenced people and put them behind the bars who just took part in some peaceful meetings or rallies, and who actually put behind the bars those people who were against the previous authority. If they still are in their offices, there will be no reform at all. So there are two key proposals: cleaning of the judge corps, not through the faked recertification, but nomination of new judges, and elimination of the political impacts or influence and their source. First of all, we are talking about the career of the judges. Well, the switches will be done by the president. You know, in the text for the amendments into the Constitution, you will not find this, because this kind of switching is hidden by the to taking the judge from one office to another one, and accordingly this has been done by the president, so far by the parliament. The parliament is eliminated from this, taken away from this process, which is good, but the president completely accumulates all those authorities and powers in his hands. In our opinion, by the way, the Venice Committee said that after the formal nomination to the office, all political organs must be distantiated from the and determine the career of the judge. We insist that all this be written in the functions of the higher Council of Justice. Also, we are convinced that neither the President nor the Verkhovna Rada, despite the fact that the Venice Commission assume that this is possible, they should not be, should have an access to the justice. They can, I mean, to the process of justice. They can be kind of, if we are talking about the nomination of the head of the Anti-Corruption Bureau, this commission actually could take care of the contest for the non-judicial, let's say, non-judge offices in the High Council of Justice. And the last thing which I would like to draw attention to, unfortunately, the political influence remains, still is there. If we are talking about the nomination or appointment of the general prosecutor, like in the effective constitution, the president is going to put forward his candidature, but this is actually absolutely political nomination, which doesn't provide for some kind of a contest or competition. And the most important is loyalty here for the general prosecutor. So our proposal is, before nomination, this or that person be selected based on the competition foundations. The same in the Constitutional Court. It calls for the Constitutional Court. It can be absolutely renovated. I mean, new persons must appear then, like the Judge Corps. Somebody said that there are no constitutional grounds in order for the judges for them to go through this kind of open contest or competition to fill the positions. There are some grounds. We have to create a new judicial judicial system. It must be simplified, not 4 tiers, not 4 levels, but according to the Constitutional Commission, they also would like to add the 5th level. So the 4 previous plus the constitutional complaints or let's say claims. Such instances should not be that numerous, because this will actually bring to zero the right to the justice, because this will mean increase of the time required. Now, why we should renovate or reboot the court or judges? My colleagues will tell about that. Good afternoon. I have a small mission to say why, as a member of the temporary commission. You know what kind of judicial system we have, but being a member of this temporary commission, being a lawyer, it is with the fear. Well, actually, I was shocked what kind of a fearful kind of judicial system we have. But our work only revealed the top of the iceberg. In our commission, members of the commission, they had very restricted rights and restricted jurisdiction, and those restriction limitations were boiled down to the events on the Maidan. And the judicial system is kind of the close-end society, as I call it. They were involved in the fighting the temporary commission. They did everything that not a single judge become responsible or punished. They actually they put the hindrance in the way of our work. They took away the members of the commission. Somebody said that after when we approved the law on renovation and the confidence to the judges of general jurisdiction, the Supreme Court gave the first 5 members of this commission. Yeah, that's true. But what happened next? Next, the judges themselves actually torpedoed the work of the temporary commission. So proceeding from that, we cannot overcome this crisis if we are going to take care only of facelifting. Now, everybody can use the computer today. If the computer operates in a normal way, but some kind of the program has been infected by some kind of virus, the computer will write on the screen, reboot the computer. The same situation is with the judicial system. We won't be able ever have the just or fair justice. Our people will never be able to go to apply to the court without the home that when they approach the judge or the court, they will be provided with a complete protection of their rights. So the situation is not only tragic, it's not only bad, it's tragic. So we really have to take care of the rebooting of the system, not the kind of some of shell or something like that, which is trying, what the presidential administration trying to do to change something with shell. But we have to change the quality of the content of that within that shell, because the quality feeling in this case, I'm sorry, I don't mean to no harm meant, but we are the people who are going to take care of justice. They might be honest, integral persons with high morality. They must have the stimulus to do their work. They must be persuaded. They must be sure that nobody, under any conditions or circumstances, nobody can actually encroach upon their rights or work. Roman already mentioned that we have been talking for a long time about Sentsov. In this 20 years sentence, which the Russian court sentenced him 20 years. But, you know, again, there was some cases, in our case, the same, you know, sanction, the article which was provides for up to 15 years of imprisonment in our country. I mean, for example, the people could be put behind the bars just for taking part in the events in the Maidan. Okay, so he is considered to be enemy of Russia, and he was sentenced to that. But even in this country, our own citizens could be sentenced to the highest possible term of imprisonment. So I do hope that, well, I hope that our efforts will have certain effect. Thank you. Good afternoon. It's very easy to be skeptic today. You can take any reform proposed by the executive power and forecast the failure in the future. Perhaps this forecast would be a right one, but it's very difficult to remain optimistic to see some kind of positive prospects or perspectives. That's why we do not abandon this work, and then that's why we came up with those initiatives. I would like to draw your attention to the fact that we are not going to be involved in any kind of confrontation. We believe that our society is self-sufficient tool to take care of the mechanisms based on which there is going to live. Especially we are talking about constitution. The right to create the constitutional norms is not reduced to some branch of the power, not the president, not the government, nobody else. That's why our proposals which we present today is the kind of public project, because it goes beyond the boundaries of the RPR, because we involved a lot of experts who participate in that, and unlike other bodies and agencies dealing with that, we are not so much regulated. They're still open to different proposals, and including those which are presented today. The key issue, rebooting of the judicial systems through the re-election of judges, and here we have kind of, let's say, we call it the fork of misunderstanding. People often ask me, well, they say that on the one hand, we have to do that. On the one hand, we become the target of very powerful criticism on the part of the lawyers, on the part of the authorities, that be and the judges specifically, who, despite anything else, they remain to be very powerful strata or substrate of society, taking into consideration how we actually elect the state mechanism or state bodies, authorities, and more important becomes this public mechanism. The further, the more difficult it is to fight for us. The key issue.
So the key question is rebooting or reattestation. Reattestation is the procedure which is applied to acting judges, and this limited to them. We believe that rebooting of the judicial system is possible so that the whole judicial core is reformed. We are talking about that a lot. They say you want to ruin the judicial system and the country will collapse. No. First, our initiatives do not provide for ruination of the existing judicial system. They provide for creation of a new judicial system. The old one will be working, but the cases will be gradually transferred to new courts. We do not envisage that all the judges are to be dismissed. First, there will be the selection of judges. The acting judges can participate in that, as well as other people who will pass exams and will satisfy the requirements. That is a wider notion than reattestation. Reattestation will not allow us to say to what extent the acting lawyers, acting judges are worse or better than others. Only if all are put in equal conditions, only this way we will get an answer to the question. And we will then understand how many old judges will become new judges. The forecasts that we hear that the mechanism of reattestation will allow to renew 30% of judicial core is non-realistic and is too optimistic, and we believe that the proposals made by the Constitutional Commission, they take into account the requirements of the society, the requirement of our projects, but this was a nice of misunderstanding which was broken, but we actually suggest what the society and the president want. They want to reboot the judicial system. Let's select the way which is the best, the most optimal. And here we need to say that whether we want to get a wider process of reforms. We have 2 minutes left, only one question. If you have no questions, then if you have something to say in the end, you're welcome. But you've said everything. Let us finish, because in a minute we are starting the next briefing. One question, but very brief one, please. Kyiv Post. I have a very brief question. What will be your action plan if you fail to force Constitutional Commission to take into account your amendments? Because we see that radical proposals are not perceived well. The proposals on liquidation, on transfer of judges were not taken into account. How will you achieve that serious changes are really introduced? What I said, we do not want to reconvince Constitutional Commission. Every one of us, we people, have the right to require the amendments to the Constitution. We are addressing the MPs, and we will require that they take into account the proposal, and how widely this will be supported by the society will basically mean a lot. The work is not finished in the Constitutional Commission. It starts from how the draft is, from the time when the draft is submitted to the Parliament, and many issues will become the issues for discussion in the Parliament. Unfortunately, when the Venice Commission was preparing the preliminary opinion on amendments to the Constitution, they were talking mostly to the representatives of the Constitutional Commission, and they managed to deceive the Venice Commission. I hope that the Venice Commission will more actively be involved into the process, and we will manage to clarify to Europeans certain issues which in the result of some manipulations were basically accepted. Unfortunately, we don't have any much time left. Thank you for presentation, and all the best to you. Our next briefing will take place now. We'll be talking